You are part of a team, the team that hired you. The team wants to pull the facts together and best present whatever helps their case. If you testify during a trial, mediation, or arbitration, your retaining attorney will ask questions to extract helpful findings from you. You will know in advance the sorts of questions that he will ask, and your attorney will know in advance the sorts of findings that you will present. Your goal is to simply and clearly present the helpful facts that you have uncovered, or the helpful opinions that you have come to when asked by your attorney-client. A further goal is to elaborate, but only enough to help the judge or jury understand, and thereby to convince them of what you say. Unless explicitly requested by one of the attorneys, your job is not to offer up information that you may have discovered, but that could hurt their case. You are only a pawn in these overall legal proceedings. The lawyers try to move you in ways that will help them. When you are answering questions from the attorney on your side, you want to be helpful, not hurtful. If you are objective and if you are effective, then your research and your efforts will have discovered both the good and the bad. You need to explain those facts in advance to your attorney-client, because he needs to know the pluses and minuses of everything you have discovered. He can then decide what is best to present into evidence, and he will ask you appropriate questions to ensure that you have an opportunity to express the positive findings. He will not ask you for any of the negatives that you have found. That, if at all, is the opposing attorney's job. Your attorney, on the other hand, is in an interesting position. He has more latitude in a deposition to object to certain questions than he will have in a trial. The posturing and the jousting that goes on between your attorney and the opposing attorney during a deposition can confuse you, especially when you're relatively new as an expert witness. You will also be confused at times when your attorney objects to something and then tells you that you can answer the question anyway. In fact, legal reasons exist for these objections, and the attorneys have to set themselves up for objections that they will be able to use during a trial just because they initially expressed them in the deposition. But another reason exists for discussing attorney commentary. You should listen closely whenever your attorney speaks in a deposition, even during a trial. During the deposition, for example, your attorney won't speak often, but when he does speak, he may have a legal purpose in mind. On the other hand, he may also be attempting to convey information to you. If your attorney explicitly tells you not to answer a question, your best course of action is to not answer the question. Just comment on the record that you are not going to answer the question on advice of your retaining attorney. During a trial, your attorney will also not be saying much during cross-examination of you by the other attorney. However, from time to time, your attorney may object to one of the cross-examining attorney's questions. You should pay close attention at those times. The objection may force the cross-examiner to rephrase their question. If not, your safest course, if the question hasn't been rephrased already, is to state that you did not understand the question, even if you believed that you did. At that point, ask that it be rephrased for you. If you can, you should use those seconds to figure out why your attorney objected and what the purpose was behind the cross-examiner's last question. Beyond that directive, you should quickly analyze if your attorney has tried to convey some information to you with his objection. He may be asking the other attorney to clarify something because he senses you will not ask for that clarification. He may also be asking the other attorney for a clarification because he senses you haven't realized the possible trick in the question that was asked. If your attorney is smart enough to do any of those things, then you will see more sparks fly because the other attorney will probably realize it also, and become annoyed at your attorney. Just leave the posturing and the arguments to them, but use the time of the interplay to figure out what advice, whether in a deposition or in a trial, your attorney may be trying to convey to you, albeit in his own sneaky little way.